Excellent. Good evening, everyone. Stop sharing my screen for a moment. Good evening, everyone. Thank you for your patience in getting started. My name is Allison Henry, and I am an at-large member of the Pasadena Rental Housing Board. I live in District 3, and I'm a tenant. And I'm also the lead of the Ad Hoc Communications and Outreach Committee. You are all very welcome to this Understanding Your Tenant Rights under Measure H workshop. We are very excited to have you. And thank you for your attendance. The workshop will be facilitated by Matthew Siegel, who's an attorney with extensive experience in landlord-tenant law. He will introduce himself more fully in a moment. We're also joined by Agnes Cho from Beehive Consulting. Thank you, Agnes, for supporting this webinar. I also extend a very warm welcome to my fellow board members on this webinar. This workshop is not legal advice, nor does it replace legal advice that you may need to seek for your own individual situation. But rather, this workshop is designed to answer questions generally, clarify what compliance with the Fair and Equitable Housing Charter Amendment looks like, and to show resources that are to facilitate the success of this charter amendment with compliance and implementation. We really hope that this workshop answers many of your questions and prevents the need to contact a housing counselor. As many of you know, the Pasadena Rental Housing Board is a relatively new body, and we are currently in the process of staffing up, and our priorities are additional housing counselors. But there is currently a backlog, so please understand that you will experience a delay in response from the housing counselors. So just a few housekeeping items before we get started. So first, please use the Q&A Zoom function to pose questions that we will try to field after the slideshow. We do have a slideshow presentation, as some of you may have noted upon logging in. We will also provide the slides and recording of this workshop after the session, and we will also try and collate your questions as we can and provide answers as appropriate in the follow-up response. There's a brief survey at the end of this workshop. It would be wonderful if you were to complete it. It will provide us some information on what our outreach strategies of ours are working, and some other easy questions that you'll see in the survey. And like I said, finally, we're recording this workshop. The slides and recording will be available to the public, as well as emailed to everyone who registered for this workshop. And just know that providing information to tenants is one way we can achieve implementation of this voter-approved law. So with that, I thank you for your attention and your just for coming tonight. And I'm going to turn it over to Matthew Siegel and go ahead and share these slides. Thank you, Matthew.
Thank you very much, Allison, and good evening, tenants in Pasadena. This is going to be an overview of the newly enacted rent control measure, Article 18, Measure H, in Pasadena. Just very briefly about myself, I am recently retired. Previously, in my work life, I was a staff attorney for the City of Berkeley's rent stabilization program. I did that for about 10 years or so. Prior to that, I was a private attorney working in downtown Oakland, primarily landlord-tenant law. And before that, I was also employed at the Berkeley Rent Board, but not as an attorney. I spent 12 years there in various roles, such as a housing counselor and compliance analyst, enforcement, things like that. So I have a wealth of experience and years dealing with rent control and affordable housing and tenants and tenant landlord issues. I look forward to, as we go forward, and like Allison was saying, the caveat to all of this is, even though I am an attorney, this is not legal advice. This is going to be sort of rent control 101. It's an overview. We will rarely dive into the weeds about some of, on any of the regulations or any of the sort of particularities of any provision of the ordinance. Of course, we'll talk about them when it's relevant. But this is more for folks who have little or no uh, understanding, and this is their first time getting some information about the ordinance. And of course, there'll be links at the end to the regulations, to the ordinance, to resources for you to discover and find out more, to educate yourself should any issue arise. And like Allison was saying, we will have some questions towards the end, and the goal is to get to as many as possible. So let's get started. Our agenda for tonight, we're going to cover five subject matter provisions of the ordinance, although there are more. These are the five that we think are the most pertinent. We're going to talk a little bit about the notice requirements. So now uh, in Pasadena, for rent-controlled units, landlords are going to be required to give tenants and the rent board certain notices, certain times for certain events. Also going to talk about the applicability or exemptions. What type of residential units are covered by the rent control ordinance, whether they are covered by the rent setting provisions and or the eviction protections as well. Next, we're going to talk about the just causes for eviction. There's 11 of them in Pasadena. This is similar to other rent control jurisdictions. We'll go through all of them. We'll touch on them. I'll give a couple of examples to help flesh things out to get a better understanding of them. We'll also talk about relocation assistance. Pasadena, as with some other rent control jurisdictions, has relocation assistance and moving expenses that will get paid to tenants when certain things are happening. We'll then talk about the rent, how the rent gets set for tenancies, how rents get increased, and also the rollback provisions to talk about a little bit briefly about whether or not your unit has experienced the rent overcharge and how to go about figuring that out. And that's going to be about it. There's a few other provisions towards the end that I will just briefly mention. And then, of course, at the end, there'll be some resources provided on the screen. This is being recorded. You'll be able to download this presentation as well and print it out and have it as sort of an introductory guide. So let's get started. So, as I said, there are certain notice requirements. And the first thing to realize is at the beginning of each tenancy, your landlord must give you a notice. And that notice has to have three things in it. It has to let you know that this rent control ordinance exists. It has to let you know that you have a right to file a petition. The petition is going to be fleshed out much later by the rent board to provide mechanisms for tenants to seek ways to lower their rent. And there'll also be an avenue for property owners to file a petition to raise their rent. That's going to come further down the road once the rent board gets further staffed up with hearing examiners. In addition, the notice has to give you instructions about how to access the rent registry, which is another component of the ordinance that is going to come in the future. Rent registry is basically landlords registering each unit on their property, providing certain baseline information, and we'll talk a little bit about that towards the end. The notice you can find, it's available on the Pasadena Rental Housing Board's website. So you have to get that notice at the beginning of each tenancy, and every tenant has to get it. So if you are a household of, if you're 3 tenants in a 1 or 2 bedroom unit, whatever, each tenant should get this notice. All right, thank you. Next slide. So we're going to talk a little bit about exemptions and the applicability of the ordinance. What units are in fact covered by this rent control ordinance, because not every residential unit in the city of Pasadena is going to come under rent control. The first category of residential units that are exempt are those that are government regulated. The most common example that I like to use is Section 8 units. So if you are a tenant and you have a voucher from the local housing authority, your rent is going to be regulated not by the Pasadena Rent Board, but by your local housing authority. These units, however, will be covered by the eviction protection provisions that we will talk about later. So this is one of those categories of units that is what we like to say partially exempt. It's exempt from the rent, how the rent goes up, how the rent goes down, but it's not exempt from the eviction protections. The next category of exemptions are hotel and motel rooms. Rooms in a hotel or a motel that are occupied less than 30 days are exempt. They're just a hotel room. Flipping that, if you somehow end up occupying a hotel or motel room for 31 days or more, rent control kicks in. In my previous experience, I saw this happen just a few times. It's very rare. But if you are a tenant and you find yourself in that situation, be aware that on day 31, you will have rent control rights. A category of exemption where it is fully exempt from the ordinance are dormitory rooms, extended care facilities, rehab facilities, of course, hospitals that have rooms, units such as that. The next category is if the landlord shares the kitchen or bath with you. So if you are living in a unit, and it doesn't have to be a house, it could be, a unit in a multi-unit apartment, and you share the kitchen or a bath with the landlord, then your tenancy will be fully exempt from rent control. There is a thing to note that exists under California state law. It's called the lodger law. I don't have the government the state citations to that, but it does exist. If you want to find out more about it, I think you could just Google California lodger law. It provides a little bit more in-depth analysis of a situation where a landlord is renting just one room to one tenant in their house. So that exists, and it sort of operates side by side with this concept of the rent control exemption of sharing a kitchen or bath. Next slide. There's more exemptions to discuss. I'll skip number 5 for a second. I'll come back to that last. Number 6, the city of Pasadena, if they have any inclusionary units or density bonus units, if you are a tenant in one of those units, you will be exempt from the rent control provisions of the ordinance, just like being in a Section 8 unit, but you will have coverage of the eviction protections. And these inclusionary units or density bonus units are most commonly created when a developer is building a project from the ground up. The city, Pasadena and other cities have a percentage of units that have to be affordable, whether it's low income, moderate income, very low income. That's usually governed by the city's housing department, and there'll be a certain percentage of units that have to be made available to those types of tenants. A density bonus unit is most commonly when a property owner wishes to develop a property from the ground up and wants to go higher. Maybe the zoning ordinance says 5 stories and he wants to go to 6. The city, let's say they grant it, and a trade-off will be a density bonus, and they might make the developer provide a few more affordable units, just like an inclusionary unit. These units are, while you will have eviction protections, the rents will be regulated through probably the city's housing department and not the rent board. Another category of exemptions are those that come under California state law called Costa-Hawkins. Costa-Hawkins was passed in 1995, and it's a state law that basically created what's known as vacancy decontrol. So vacancy decontrol basically says that if your unit, your property, your building was built after February 1st, 1995, anytime there is a vacancy, a total turnover in the unit, the landlord can reset the rent at market. Previously to Costa-Hawkins, some rent control jurisdictions did not allow that. That is no longer allowed to have this constant rent control of a unit for these types of units, if they were built after February 1st, 1995. Under Costa-Hawkins, in addition, single-family homes that are rented, the way I like to put it is fresh, after January 1st, 1996, also be exempt from the rent control provisions of the rent control ordinance. So if you were living in a single-family home and you moved in anytime after January 1st, 1996, you will be exempt from the Pasadena rent control rent provisions, not the eviction provisions. You still will have the eviction protections under the ordinance, which we will discuss in depth later. So that's another category of exemptions under Costa-Hawkins. Number 5 above is a very interesting provision in this rent control ordinance. I don't believe I've seen it before. And they define it as temporary tenancy. So under the ordinance, what is a temporary tenancy? Well, first, it has to be in writing. Secondly, cannot be longer than 12 months. It could be 1 month. It could be 11 months and 29 days. Third, the relocation benefits that we touched on previously do not apply to these types of tenancies should the landlord want or need to evict that tenant. And fourth, the restriction on a property owner, should they choose to go down this route and rent out their unit via this form of exemption called temporary tenancies, they're restricted. Within any 36-month period, they can't have any tenancies that cumulatively last longer than 12 months. So for example, if I move in and rent under this provision for 6 months, and then I move out, and the property owner said, that was great, I want to do that again. It's a visiting professor, it's a student taking a class from abroad who visits here. I could do that. The landlord could do that, but they couldn't do it for 7 months. That would violate the 12-month rule within a 36-month period. Of course, once that 36-month period expires, the clock will reset and the landlord can start all over again. So those are the eviction/units, the applicability section of the ordinance. And you find that in section 1804. If you have a copy of the ordinance and you want to explore that in greater depth, that's the section that you can find that in. Thank you, Allison. Next slide. So most rent control jurisdictions, and Pasadena is one of them, along with regulating the rents and how much the rents can go up any particular year, also has now what's called just cause for eviction, or some jurisdictions call it good cause for eviction. Prior to the enactment of this ordinance, the landlord, if they wanted or needed to evict you, they didn't really need a reason. They couldn't evict you for a illegal reason, discrimination, things like that, but they didn't need a cause. They didn't need a reason. Now they do, and there's 11 of them. And the way I like to think about them is there's 7 of them where the tenant did something wrong. That's where at the top of the screen it says fault. And there's 4 of them where the tenant did nothing wrong, but the landlord will still be allowed to go forward with an eviction. So we'll talk a little bit about each one of these. The first one is fairly obvious, non-payment of rent. One caveat I want to raise is that while I think all of the COVID eviction moratoriums have expired, I'm not aware and I'm not knowledgeable about how Pasadena or LA County is handling unpaid rent during COVID. So non-payment of rent, when I'm talking about it, it's post-COVID rent. Of course, if you are in a situation where you have a lot of unpaid rent and it has accrued during the COVID era, you should contact the rent board, and of course, maybe seek legal assistance if that becomes a dispute. So non-payment of rent, of course, is pretty straightforward. The second grounds for eviction is the breach of the lease. You violate the lease term. And I think the real important thing to understand when we talk about lease violations is under the ordinance, the violation has to be substantial. And in addition, the term of the lease that you're violating has to be material. Now, the law does not define either one. It does not define what is substantial. It does not define what is material. Every case is going to be unique. You can think of a number of examples. So for instance, if there is a no smoking provision in your rental agreement and one day you go out and smoke a cigarette on the balcony, and that's the only time you do it, and somehow the landlord wishes to evict you over that, well, it's probably a material breach of the lease, but it's probably not substantial. If you are a habitual smoker on the balcony violating the lease, then it probably will be substantial. And of course, I say probably because for all of these things, when we're talking about evictions, most of it's going to be case by case and fact specific. But that is one of the things to think about should you end up in a situation, unfortunately, where the landlord is trying to do an eviction based on a lease violation. That violation has to be substantial, and the lease provision has to be material. The third grounds of eviction, where the tenant is at fault, as defined in the ordinance, is if you are committing a nuisance or substantially damaging the property. So what does that mean? When we talk about nuisance, we don't talk about, oh, you're just, nagging someone somehow. Basically, the ordinance defines it as the tenant is unreasonably interfering with the comfort, uh, health, or safety of residents, or, interestingly, in Pasadena, immediately adjacent neighbors. So first, that last part, which is very interesting, the ordinance does not define what an immediately adjacent neighbor is. Perhaps there'll be regulations going forward that fleshes that out. I guess sitting here today, common sense for me would say the property to the left of me, the property to the right of me, maybe the property behind me. That could be maybe more of a stretch. Probably not the property across the street, because I don't believe that's adjacent. But that is a component in this ordinance that is unique. But when we talk about unreasonable interference with the comfort or safety, what are we talking about? It has to be pretty substantial. Again, we use that word. It has to be pretty serious. Things like harassing, stalking, of course, threats, threatening, things like that. If a tenant is doing that to another tenant or immediately adjacent neighbors, they could find themselves being evicted under a nuisance theory under this provision of the ordinance. The fourth one is pretty self-explanatory. You could be evicted if you are in your unit selling, possessing, or manufacturing drugs. When I gave this presentation yesterday for the property owners, the only point I made was that it's probably a good business practice if you are the property owner to have something along the lines of either police reports, an arrest, or a conviction if you're going to go forward with something like this. For all of these, the caveat or the advice that I would give to any tenant who finds themselves being threatened with an eviction or has received an eviction notice is to immediately contact both the rent board and or an attorney. There are several nonprofits in Pasadena and LA County, I believe, that can provide some level of assistance for you. But you certainly want to do that, and you want to do that quickly, because if you have received a eviction notice, you are under the clock. You only have a certain amount of days to do something, to respond in court somehow, or to cure whatever it is the landlord says needs to be cured. So if you get an eviction notice, do not just sit on it, no matter what you might think about it, no matter what you might think about the legitimacy of it. You should take immediate action. The fifth provision, just cause for eviction when the tenant is at fault, is when a tenant refuses to renew a lease. And we see this in a lot of rent control jurisdictions as well. And this is when the example is you might have a 1-year lease. It's month 10. Your landlord says to you, your lease is expiring. I want you to renew. Matter of fact, I insist you renew. I like all my tenants to be on these 1-year leases. They are allowed to do that. That is not against the law. The landlord can compel you to renew. And if you refuse, if you say, I don't know what I'm going to be doing for the next 12 months, I think I'm going to be moving in 5 months. I'm not comfortable with it. You can end up being subject to an eviction. The caveat to this provision is that it has to be identical terms. So if when you moved in on January 1st, 2023, and your lease was 5 pages long and had 15 provisions in it, and the landlord gives you another lease that's 20 pages long with 150 provisions, that's not the same terms. They have to be practically identical. The landlord can't take out things like now there's no pets when before there was, now there's no smoking when before there was, things like that. So, but that is a good cause for eviction, and you could end up facing one if you do refuse to renew when the landlord is asking you to do it. The sixth grounds for eviction is really rooted in California state law, and that is California Civil Code 1954, where the tenant denies the landlord access to the unit. It's the right of entry. So in California, landlords do not have an unfettered right to enter your unit. They can't just cross that threshold. It's your unit. You are in possession of it. You have what's called a possessory interest in that unit. You have a right to be there, free from the landlord just entering whenever they want to or think they can. But California state law governs the grounds for the landlord to enter the unit. And the bullet points that I would hit on that is that when the landlord wants or needs to enter your unit, he has to give you written notice. 24 hours is presumed reasonable. The most common grounds for entering the unit is, of course, an emergency. And if there is an actual emergency, the landlord does not need to give you written notice. The example I like to use is the next door neighbor calls the landlord and says, I smell gas. I'm 100% sure it's coming from this unit. Maybe the stove got left on. I don't know. Get over here. We don't want the building to blow up. You go over, you confirm it. You can enter the unit if the tenant's not there. That would qualify, excuse me, as an emergency. Um, the other grounds for which the landlord can enter your unit is to do necessary or agreed upon repairs. Agreed upon is pretty simple. Necessary is not what the landlord thinks is necessary, but what some agency says is necessary. Maybe there's code violations that have been issued by the city of Pasadena, things like that. Perhaps the landlord's insurance company has done some drive-by and says, you know what, something has to be fixed, the roof has to be repaired, common area lighting has to be done. It might have an impact on your unit. So I think you need to fix all that. That might be a little wobbly because it's not a government entity, but of course, the most conservative thing would be to grant that access, provided written notice is given. The other main category for providing notice is for entering the unit is when the landlord wants to show it to prospective tenants. If you've given notice that you're moving out, appraisers, realtors, prospective buyers, things like that. That is good cause to enter your unit. The landlord, again, like I said, has to give you notice, and that notice should spell out the day, the time, the reason, and the length of time. Sometimes the landlord doesn't know whether repair is going to take 40 minutes or 4 hours. That's legitimate. So if you get a notice that says, I'm coming in to do these 7 repairs that you want me to do, and it's going to take between 8 o'clock and 5 o'clock, that's probably going to be reasonable. But if the landlord just gives you a notice that says, I'm entering, to do work and I'll be there on Tuesday, but doesn't really say when, that's probably not a good notice. If you find yourself in these situations regarding entering the unit, which can get highly charged, it can get personal, they're coming into your apartment, they're coming into your house. The advice I've always given to both landlord and tenant is try to work it out. Most people will be reasonable, the landlord and the tenant. And if your landlord is being reasonable with you and sort of describing in sufficient detail what they need to do, why they need to do it, and when it needs to be done, you're probably best off being reasonable as well. Of course, sometimes the parties can't agree, and the landlord's remedy or option is to try to proceed with an eviction if they want to. But most of these cases that I've experienced in my 20 some odd years at rent control programs, these often get worked out. The final one basically says when the subtenant is in sole possession at the end of the lease. And we don't have enough time to really dive deep into this whole uh, you know, law about subtenancies. What's a subtenant? What's a master tenant? When is a unit being sublet? When is it not? We're not going to get into that. So I'll just give you a classic, very simple example, and hopefully, it just sort of brings it home. You're renting your studio and after 9 months, you want to go abroad for 3 months, and you choose to do that. And let's assume subletting is allowed. You find a subtenant, the landlord agrees, everything's fine. You tell the landlord, oh, it'll probably be about 3 months or so. 3 months go by. You then write to the landlord and say, I love it here. I'm never coming back. Um, you know, I'm not going to be in the unit anymore. The subtenant who's there is now in sole possession, and it has to be at the end of the lease. And if the subtenant does not leave, that could be grounds for an eviction. So that's really sort of the most broad-based type of example that I can give, because other than that, we'd have to probably spend about a half hour diving deep into the whole law canon about subletting and how that plays out in rent control jurisdictions. And we just don't have time for that. Okay, thank you, Allison. Next slide. So these are the grounds for eviction where the tenant has not done anything wrong. And there are 5 of them. The first one is when the landlord has to make, again, has to, not wants to, necessary and substantial repairs. And for this, there's 4 things that we can touch on. One is before the landlord can even try to evict you and give you an eviction notice under this grounds, he needs to have all his permits lined up. He needs to have all his permits in hand. He can't say, I'm getting my permits next week, or I'm getting my permits tomorrow, or I think I might need permits, I don't know. That's not going to be sufficient to go forward with an eviction where the landlord wants to do necessary and substantial repairs. The second criteria that a landlord has to meet in order to evict under these grounds is the repairs have to be needed to bring the unit into compliance with all applicable codes. And again, these are generally going to be the housing codes in the city of Pasadena that generally deal with basic concepts of habitability. The electrical works, the gas works, the walls are good, the roof is good, things like that. The third component to this, in order for a landlord to go forward with this type of an eviction, the city has to weigh in and actually opine that you as the tenant need to vacate. How that's going to play out, maybe there's dialogue between the rent board and the city. I'm not aware of that, but that is in the ordinance, and that is a provision. The thing to understand for these categories of for this category of an eviction is it is temporary. It is not permanent. So if you find yourself evicted under this provision, or you leave voluntarily after the landlord gives you a notice, a proper notice under this provision, you have the right to return at your old rent, and you, of course, also have the right of first refusal for a vacant unit that's in the building. The second grounds for eviction is rooted in California state law, and it's called the Ellis Act. Very popular in Los Angeles. There's been at least hundreds of them done. The Ellis Act is found in California Government Code 7060. It's very dense. It's very difficult to read and work your way through it, even as a practicing attorney. It's problematic, but it's there. And what the Ellis Act allows is for a landlord to basically say, I am going out of business. I don't want to be a property owner anymore. I don't want to be a landlord of this building anymore. I'm clearing out the building, and they are allowed to do that. Again, we can probably do a separate presentation just on the Ellis Act. We don't have time for that. So if you find yourself the recipient of An Ellis Act eviction notice, you'll know it. It will probably come with a packet of documents, a whole lot of paperwork. The eviction notice is lengthier than a regular eviction notice under any other just cause. There's a lot of provisions in place that give tenants some protections. We don't have time to get into that. The thing that I can say tonight is that if you are being evicted under the Ellis Act, relocation benefits do apply, and we'll talk about that a little bit later. The third grounds for eviction for where the tenant has done nothing wrong is if there's a government order to vacate, and really the common example is earthquake and the building gets red tagged and you have to leave. That is grounds for eviction, but as with the number one above, you have the right to return, the old rent, and to any vacant unit. The fifth one is what's commonly called owner move-in evictions, and you'll see that in most rent control jurisdictions that have eviction protections. As with the Ellis Act and as with things like the rent registry, we could probably do an entire presentation just on owner move-in evictions. So what I'm going to do, I'm just going to hit some of the highlights. So in Pasadena, a landlord can go forward with an eviction to move in themselves, their parents, their adult children, their grandparents, or their grandchildren. In order to do so, person doing the eviction has to own at least 50% of the property. So if your landlord are three brothers and you find out they each own 33 1/3% of the property, and you get an eviction notice from one of them or both of them or all of them, that eviction notice will not be valid. Neither one of them owns 50%. If it's three brothers and one owns 50%, that brother can go forward with the eviction based on whoever it is he wants to move in. The other thing to understand is that another protection that tenants have is that there's no owner move-in eviction if the landlord or the enumerated person or relative that they want to move in already lives on the property. So if I'm brother number one and I want to move in, if I want to move in, my 22-year-old son into your unit and you're in unit C, but my son already lives in unit B, I cannot do that eviction because my son already lives on the property. In addition, there are these other tenant protections, and briefly, there will be no owner move-in eviction of you as a tenant if you live there for 5 years. So that is sort of a baseline requirement. So if you live there for more than 5 years, or 5 years or more, and you are either 60 years old, older, disabled, or terminally ill, then you will have a protection from any type of owner move-in eviction. There's a slight wrinkle to that we don't need to get into, but it's good to just have a good baseline understanding of these basic tenant protections for owner move-in evictions. I just want to take a look and see how we're doing with time. I think we're doing okay. All right, next. So eviction notices have their own requirement, just like the initial notices we talked about, where you had to get notice of the existence of the rent control ordinance. If you get an eviction notice and you're in a unit that's covered by the eviction protections and the eviction provisions of the rent control ordinance, that notice has to state the grounds and it has to allege compliance with the rent control ordinance. When I was talking yesterday with property owners for this, the best practice for the property owner would be to say, I'm evicting you under section 1806, number 9, subsection C, owner move-in eviction, as opposed to just saying, I'm evicting you to move in my brother. Both are probably okay, but the best business practice for the property owner, and now for you as a tenant to be aware, is that the grounds for the eviction have to be stated, as well as the landlord must allege that he is in compliance with the rent control ordinance. The landlord also has to file that eviction notice with the rent board within 3 days of serving you with that eviction notice. The landlord also has to give you a form that summarizes the eviction protections, and you can find those also on the rent board's website. What's good to know as a tenant, if you are being served with an eviction notice. The landlord's failure to comply with the above bullet points can be an affirmative defense to an eviction. And what does that mean? It means that even though the landlord might be right um, in what he is trying to do, like I really do want to move in my adult child, if I'm not complying with these above criteria, I can win my case um, at some, along some pathway of the litigation of any sort of eviction lawsuit. So it is an affirmative defense to an eviction if the landlord is not complying uh, with these provisions. Finally, relocation is required for no fault, just cause evictions. Okay, thank you, Allison. So earlier on, we talked a little bit about this concept of relocation assistance being available to tenants. You can find that in section 1806 of the ordinance. And there are five fact patterns, five ways that tenants are entitled to receive relocation assistance. First is when the landlord is evicting for necessary and substantial repairs, owner move-in, the Ellis Act, government order. And then there's the fifth one, which is rather unique, I think, to Pasadena. It's when the tenant is unable to pay a rent increase in excess of 5% plus the AGA. And when we say AGA, what we mean is annual general adjustment, which is the yearly increase that tenants in rent controlled units um, have to pay with the landlord is charging each year. So for this coming year, it's 2.75%. So an example would be if you're in a single family home and your rent is $4,000 and so you're not covered by the rent provisions, the rent control provisions of the ordinance. Your landlord gives you a 20% rent increase going from $4,000 to $4,800. Well, if that increase is in excess of 5% plus 2.75% in this case, and you can't pay it and move out because of it, you will be entitled to relocation benefits. Let's go to the next screen. So what we see here, especially and also on the far right-hand corner, is moving expenses. I just can't see it because of the video. These are the payments that a tenant household will be entitled to receive, and it's based on two things: the number of bedrooms and the number of years that a tenant has been in possession in the unit. The bottom part of this chart says additional payments for special circumstance households. And what that means is if anyone in the household is 60 years old or more, disabled, terminally ill, or anyone in the household is a minor child, then that household will be entitled to these amounts. It's for the household, it's not per occupant. The process for the relocation assistance, we're not going to get into that today. There's a regulation that the Rent Board recently passed. I think it was back in September 27th. You can look at the agenda packet on the website for that. It lays out in great detail, should you be in this situation, this is how it works. So again, we just don't have time to walk you through the myriad number of steps that need to be followed to actually access this relocation assistance. All right, next. Thank you, Allison. So let's talk a little bit about the rent. This ordinance became effective on December 22nd, 2022. However, it had a rent rollback, or another way to think about it, a rent reversion. The rent goes back. So even though the voters passed this in the November 2022 election, and it took effect a couple of months later, what it basically said is if you are covered by the rent control provisions of the ordinance, your initial rent was what your rent was as of May 17th, 2021. If you moved in after that date, then that first rent that you paid, whether it was August 2021 or January 2022, or any other date after May 17th, 2021, that is your starting rent, your initial rent, your base rent. The rent increases, and we'll get to other different rent increases, I think, in the next slide, but the easiest rent increase to talk about is the most recent one passed by the rent board. The ordinance provides for the mechanism of how your AGA, your annual general adjustment, gets decided. And for the first AGA, it's 2.75%. And it runs, not a calendar year, not from January through December, not a fiscal year from July 1st through June 30th, but this other year from October 1st, 2023 through September 30th, 2024. The landlord can take it anytime between those dates. The thing to be aware of is that there is this concept of no banking is allowed. And we'll talk about that in the next slide as well. Basically, what no banking means is that any rent increase that a landlord was previously entitled to, but did not take when they should have taken it, is lost. You use it or you lose it. So we'll talk about that a little bit on the next slide as well. As with other types of notices, you're entitled to a rent increase notice, and that rent increase notice has to tell you about the existence of the law, just like that first notice that you get at the beginning of your tenancy, and your right to file a petition, just like that first notice that you would get at the beginning of your tenancy. A couple of prohibitions that would prevent the landlord from taking an otherwise allowed rent increase is if there are severe code violations. If there is an order from the rent board, or if the landlord is not in compliance with the rent control ordinance. All three of these we can discuss in greater detail. Just very briefly, I would just say severe code violations. If you think that that your unit has severe code violations, you probably want to contact a housing code inspector through the city or the county, and they would come out and do an inspection and issue a report. You probably don't want to be in the position of arguing unilaterally, oh, there are severe code violations, so I'm not going to pay this increase. So sort of a best practice or a conservative practice from a tenant perspective would be to get some independent agency or authority to actually say there are severe code violations before you start advocating for some sort of rent decrease. Order of the board will come in the future when the rent board starts having hearings on tenant petitions to lower the rent, and non-compliance with the article is sort of self-explanatory. There's a lot of requirements that are in the rent control ordinance. If you think your landlord has violated or is not in compliance with any one particular part, again, the best thing I would advise is to start off by talking to a housing counselor at the rent board. And of course, if you think you are on this track that I'm not going to pay this increase, you should know that there could be a dispute about that. You could find yourself on the other end of a 3-day notice to pay rent or quit. Okay, thank you. Next slide. So not every tenant has been in their unit as of May 17th, 2021. Some tenants moved in after that. So before this AGA was just passed by the Pasadena Rent Board, the rent control ordinance had provisions for certain types of rent increases that your landlord could have taken. And the first increase to talk about is if you are a tenant and you moved in before May 17th, 2021, your landlord was entitled to a 6% increase. If you moved in between May 18th, 2021 and May 16th, 2022, your landlord was still eligible for a rent increase, but that amount is going to be different based on what month you moved in. And the best way to try to figure that out is if you go to the website, the Pasadena Rent Control Program has a rent rollback form that walks you through step by step, almost sort of like filling out your taxes. If this, then that, then subtract this from that. It sounds complicated. I've looked at it. I think it's doable. I think it makes sense. So you should give that a shot if you think you're in that situation. And of course, if you moved in after May 17th, 2022, you are subject to the first annual general adjustment that has been granted, which is 2.75%. The thing to realize is that if you are in category one or category two on this slide, remember what we said before about no banking. So your landlord was eligible to take one of these two increases, but now is not. So if your landlord gives you a notice that has a lot of numbers on it, and some of those numbers say, well, you moved in 20, on May 1st, 2021. So now I'm raising your rent 6%, plus another 2.75%. That 6% increase is gone. I do not believe your landlord will be able to take it. So that's how these rent increases have worked in the past and are going to work in the future. All right, thank you. Next slide. The rent rollback process. So again, the place to start is the rent rollback form that is available on the website. Once you fill out that form and you think the numbers add up for you, that you have somehow been overcharged, there are certain steps you have to take. We're just going to touch on them briefly. The first one is you have to submit a written request to the landlord, basically outlining the numbers, how much you've been overcharged, things like that. The landlord has 10 days to get back to you to either roll back the rent or, of course, provide you a refund in the form of either, a payment or a rent reduction. If the 10 days go by and you haven't heard from the landlord, you can then file a written notice of rent withholding, also on a form that is available at the Pasadena Rent Board website. Within 5 days of providing that written notice or 5 days of your first payment, you have an obligation to file both of these notices, those first two notices that are in bullet point 1 and 2, with the board. This is an administrative, bureaucratic process that you have to follow. If you don't, you're at risk of not getting your rollback or your refund. If you follow these procedures, and again, they're more complicated than just these 3 bullet points, and you should definitely access a housing counselor or the website or an attorney if you think somehow you've been overcharged. But the thing to realize is if you go through the rent board provisions, their procedures, and the landlord tries to evict you, and you find out, and you're correct, of course, with your math or your analysis, that is an affirmative defense to an eviction. Also, as just the point to understand, is this process about the forms and the filings and going through the rent board, it's not your exclusive remedy. When I say that is you have other options as a tenant. You can forego this if you think you're right. You can do the math yourself and just communicate to the landlord. My rent should be $500 less. You've overcharged me $2,000. If I don't get a check from you in 10 days or 5 days or 30 days, I'm going to withhold it myself. You would be allowed to do that, but you're running the risk, of course, of possibly being evicted by doing that. So that's just a risk every tenant, that's a judgment call that every tenant has to make. And this whole process of the rent rollback provisions became effective as September 1st, 2023. And finally, there is no rent increase unless that rent is first reduced. Thank you. Okay, next slide. And we're getting towards the end, and we're doing good on time, and I really appreciate everyone's efforts. There are 4 other provisions of the rent control ordinance that I just briefly want to touch on. One is in Pasadena, your landlord has to give you interest on your security deposit. This concept does not take effect until January 2025. So you can sort of put it on the back burner. I'm sure the rent board will be communicating with you and with landlords as January 2025 gets closer. Currently, the security deposit interest rate is 0.41%, so it's very small, but it is something. And actually, if you have a big deposit, then maybe it's not so small, everything being subjective. Another provision of the rent control ordinance is the concept of this rent registry. We talked about it very briefly. Going forward, landlords are going to have to register your unit. They're going to have to provide some baseline information about your tenancy, when you moved in, what your deposit is, maybe what the rent is, who you are, things like that. Third, the rent control ordinance also has what's called a tenant buyout program. And I'm just briefly going to talk about what a tenant buyout is. And it's sort of self-explanatory. It's when a landlord and a tenant agree that the tenant is going to move out in exchange for something. That something could be, I will waive the back rent, or I will give you your deposit back, or I will give you money to move out. And that compensation can be anywhere from 3 figures to 6 figures. In my experience, I've seen all sorts of numbers. It all depends on the situation. Every case that deals with a tenant buyout is case by case. Just to know, it is not unlawful for your landlord to offer you a buyout. It won't be allowed if the landlord is badgering you, harassing you, threatening you, constantly saying to you, tenant buyout. Why aren't you doing this? You need to do this. That won't be allowed under the ordinance. And vice versa, there's no prohibition for you to approach the landlord and say, hey, I'm interested in moving. Let's make a deal. And the landlord can bargain. And if you come to an agreement, that's great. There's more in the ordinance about the tenant buyout. You can find it in section 1810, but I just wanted to touch on it briefly for this presentation. And finally, there is a petition process and a hearing process that is being fleshed out, and at some point will be finalized and fully staffed, that will allow tenants to file petitions to get rent reductions. And there will be a hearing. When you file such a petition, it'll be before a hearing examiner hired by the board, and it will operate, a little bit like a more informal case. It's you can have attorneys if you want. You can do it yourself if you want. You present evidence. There's witnesses. All of that. It's sort of like going to small claims court, and you just put on your case, and the landlord puts on their case, and you go back and forth. Practically every rent control jurisdiction has a fully fleshed out petition process and hearings process. Precedent is working on it now, so that's why I didn't want to go too deep into it, because we don't quite know exactly how that's going to look. So I think that does it. The last slide. If you're printing it out, there are all these other additional resources, the actual rent control ordinance, the rent board website, the email link if you need or want to contact a housing counselor at Pasadena Rent Control Program. Like Allison said, there is a backlog. It is going to take a while to get a response. Bear with them. They're trying to get fully staffed as soon as possible. There's a couple of people now on contract, but there is a backlog, and just please, have some empathy and compassion for the folks that are answering these emails. They're doing the best they can. And I think that does it. And we could probably spend some time answering some questions. And again, I thank you all for your attendance tonight.
Thank you, Matthew. And I'll go ahead and pass it to my colleague Agnes, who I know has been collating the questions.
Yeah, so thank you, Matthew, for the presentation. It was very informative. We hope that you learned something new tonight. We have gotten quite a few questions in the chat, and rather than address them kind of one by one, because some of the questions are about the same topic, what I'll do now is I've been kind of collecting the questions and organizing by theme, and we'll be asking Matthew to kind of provide more clarity. Now, you may hear him say, consult a housing counselor, consult an attorney. Unfortunately, this webinar, we're not able to provide housing counseling or legal advice. So we'll be addressing and clarifying kind of how the ordinance applies to tenants in general. But if you have additional questions for your specific scenario, please contact the rental housing at cityofpasadena.net, an email to connect with the housing counselor. So Matthew, the first set of questions that we received was around clarification around how the ordinance applies, how the charter applies to Section 8 tenancies, and just to really clarify in what cases Section 8 tenancies are and are not exempt. So can you provide that clarification?
Yes. So if you are a Section 8 tenant, you have that voucher from your local housing authority that says you're just paying X and the landlord pays the balance. Um, the, the rent that you pay will have nothing to do with the Pasadena Rent Board, like nothing. That rent will be regulated by the local housing authority in conjunction with the United States Housing and Urban Development Program Department. That's the department in the federal government that oversees Section 8 programs. So that rent increase has nothing to do with Pasadena. If you are a Section 8 tenant, hopefully or probably you have a case for your unit through your either local or county-wide housing authority. You will be protected, however, by the eviction protections of the rent control ordinance. In addition, you might have an extra layer of eviction protection through federal regulations. I can't go too deep into that. But so if you're a tenant in a Section 8 unit, you will have those protections.
So one thing that I do want to clarify is that we understand that there are different types of Section 8 tenancies. And that apply to people's kind of unique situations. So unless the Section 8 tenancy is exempt from the charter's rent stabilization or the just cause eviction provisions on other grounds, both provisions will apply. Kind of in other words, if a tenant lives in a building where all other units are subject to just cause and or rent stabilization provisions of the charter amendment, their tenancy is not exempt merely because they had a Section 8 voucher. However, if they live in a tax credit unit that's operated by a nonprofit and they have a Section 8 voucher, then the just cause provisions may not apply because of the nonprofit exemption. So again, it depends, but generally, and the board, I know that the board is working on issuing kind of additional information to clarify questions about that community members have about this.
Thank you.
Matthew, we also have a set of questions around rent increases. Can you briefly re-explain the no banking provisions? So for example, if someone's rent was increased in January of this year, can their landlord increase the rent again this year? Or, kind of when would they have to, when can they take the next rent increase?
So I believe the ordinance specifically limits a property owner to one increase a year. So again, every case is going to be unique. So just hearing my landlord raised my rent in January of 2023, we need to know more what the unit is, what type of rent increase they got. If we go, I think the only thing that they would have been allowed to raise it to, and if the increase was in January of 2023, would be the coming 2.75% AGA. That's sort of my understanding. Of course, again, with rent increases for certain units, some of these might be no-brainers, but a lot of these we're going to need the program or a housing council is going to need a lot more information than that. But basically, one increase a year is written into the ordinance. The landlord can't take 2, 3, or 4 increases. So if you got an increase on January 1st, 2023, valid or not, let's assume valid in some way, and the landlord is giving you another increase now in November 2023 of, let's say it's the 2.75 AGA, my sense, and again, this is not legal advice, but just going off these general principles, is that there's a good chance that first increase you got 9 or 10 months ago probably was not allowed. But again, you're just going to get that caveat from me, right? I don't want to get it wrong because I'm not your attorney. I don't have all the facts and specifics about your unit in front of me, but that's sort of my best thinking at this point.
And if you have specific questions, please email a housing counselor. We're going to sound like a broken record after the end of this section. Matthew, we also got a question around late fees. Does the charter amendment, to your knowledge, cover how much late fees can be attached to rent?
No, it doesn't. Late fees, there's a couple of cases through the state of California that talk about late fees. Late fees cannot be put into an eviction notice for non-payment of rent, but late fees are allowed. I'm going off memory here. A general rule of thumb, I think, oh boy, it's a percentage and it's based on an older case, I think out of Los Angeles. I know this is ambiguous, but it's just to give you sort of a real ballpark, estimate of it. I want to say something like 5% might have been found reasonable. So if you have a late fee provision in your lease and you think it's way above and beyond, something like over 5% or thereabouts, you might want to consult an attorney for that. And again, I think the case law just talks about reasonable. I don't think it drew a bright line in the sand. So it's sort of a moving target about just how much a late fee can be.
We also got a question about kind of lease terms, and can you clarify what it means to be kind of the terms of the lease and what substantial changing for the terms of the lease may be? For example, if you want to renew the lease, but there are changes to the lease terms, and of what would constitute changes to the lease term?
Yeah, so the example I gave is you have a lease that says you can have a pet, right? Because that was important to you moving in, and you got yourself a cat. And the lease says you can have one cat. Well, let me put it this way: the lease says you can have two cats, right? Because that's what you heard, and you didn't want to abandon one of your cats. The landlord gives you a new lease. Um, they don't like the two cats. The new lease says one cat. Maybe it says no pets at all. That's a substantial change in the terms of your lease. So you would have the landlord would not have the right to compel you to renew that new lease. It is substantially different. Can it be a little bit different? Again, every case is going to be unique to itself. The practice that I advise property owners is don't make any changes. Of course, the rent changes each year based on the law, but everything else should pretty much remain the same. It should really just be a renewal document that tenants are signing. The best practice for your landlord is not to hand you a new 20-page lease and say, sign this now to start all over again. It really should just be a simple piece of paper, like an addendum to your first lease that says, I'm renewing from, from November 1st, 2023 through October 31st, 2024. But some landlords, they think they have to give a whole new 20-page lease to their tenant each and every year. I think they run into problems by doing that. But if that's what they choose to do, you should look at the new lease. And if you see things that are different, that are out of whack, that you disagree with, remember, you can agree with the differences, right? You might not have pets anymore, and you might not be getting a new pet. You might not care that the provision now says no pets. Go ahead and renew if you want. You don't have to say no, but you could say no if it's substantially different.
Matthew, this is another question about a lease. When a lease expires, I'm guessing when a written lease expires, can a landlord go month to month?
Yeah, so what happens, it really doesn't matter if the rental agreement that you had was written or oral. Oral leases are allowed. You can have that. In my experience, I've seen landlords and landlords and tenants that have had handshake agreements, and that tenant has been there for decades. Problem, of course, arises as to if a dispute ever comes up. What are the terms? He said, she said. What evidence does anybody have? But as far as this question goes, if you have a lease for a certain period of time, let's just say commonly a year, and the landlord does not ask you to renew, and the next month rolls around and you pay your rent, your tenancy has converted to a month-to-month tenancy. So if the landlord accepts rent on month 13, for example, on a 12-month lease, without forcing you to renew or risk eviction, and you pay the rent and the landlord accepts the rent, in most cases, your tenancy has automatically converted to month to month.
My next question
I,
is actually for Allison, who has a bit more kind of local context. Allison, we've had some people in the chat who are from Sierra Madre or Altadena and who live in kind of unincorporated LA County and outside of Pasadena. Do you have any recommendations where people can go to? And I know that Measure H applies just to residents who reside within the city of Pasadena. Do you have any recommendations for where these residents can go for more information about their protections and their rights?
Absolutely. And this is where it's important for us to know if we live in an incorporated city like Pasadena, like Alhambra, or unincorporated portions of LA County like Altadena. If you are in an unincorporated area of the county, I've put in the chat the DCBA. LA County does have some rent stabilization and tenant protections. So if you're in Altadena, you may very well be able to avail of those. I would actually direct people to LA County first. They've been great about being able to at least respond to folks in terms of like clarifying things. And then if you're an incorporated city, I can't remember offhand if Sierra Madre is an incorporated city. I believe it might be. And if it is its own city, then right now Sierra Madre doesn't have any protections for tenants. So you're really at the mercy of your city council. But yeah, thanks.
We also got a few questions about relocation assistance. So there was one question about whether relocation assistance would apply for tenancies sorry, I'm just trying to get the actual understand the situation. So always with these cases, there's a lot of detail. So I guess generally, Matthew, do you know when relocation assistance goes into effect or what kind of when it applies?
Yeah, so in the ordinance, it's section 1806, I think. We find the provision about relocation assistance in general. When a landlord is seeking to evict you under grounds 8 through 11, that's when relocation assistance kicks in. And then in addition to that, and that was substantial and necessary repairs, the Ellis Act, owner move-in eviction, and I'm forgetting one off the top of my head. And then, of course, there's that last one we talked about, the rent increase that exceeds 5% plus the AGA, and you can't pay it. Those are the only conditions in the rent control ordinance that you would be possibly eligible for relocation assistance.
And does relocation assistance apply to condos and single family homes? Can you share a little bit more about
Yes.
which units?
Sure.
Yeah.
Yeah, those units would be covered, even though they might be exempt from the rent control provisions of the rent control ordinance. They are covered by the eviction protections of the rent control ordinance. It doesn't matter when it was rented. It doesn't matter when it was built. Those are residential rental units under the ordinance. And again, if the landlord is trying to do an eviction under one of those grounds, then relocation assistance would probably kick in.
We also have a set of questions around services. About maybe some landlords or property managers, I think charging for utilities and that were previously provided, and as well as kind of it was just general. So generally, can you speak to about kind of services that are included in rent and kind of how they apply to kind of how they apply to leases?
So, if I moved in and I'm covered by the rent control ordinance, that's the first step. If you're a tenant doing any analysis, I'm in a residential unit. I'm in the city of Pasadena. Am I under rent control? Most of the time, the answer will probably be yes, but there are exceptions, and we talked about that in the applicability sections. If the answer is yes, and I'm covered by the rent increase provisions, And when I moved in, my rental agreement said the landlord pays water, and a year goes by, and the landlord wants to change that and say, nope, now you're going to pay for water. That would be an unlawful rent increase, basically. The terms of your rental agreement remain the same. A change in ownership does not impact your rights under your rental agreement. So if the property gets sold in the middle of your 12-month lease and the new landlord says, this is insane, water bills are going through the roof, I want my tenant to start paying for it, they would not be allowed to do that. And ultimately, what I believe Pasadena will be doing through their petitions and hearings process is if a tenant finds themselves in those types of situations, I believe those tenants would ultimately be allowed to file petitions basically saying my rent is being illegally increased because the landlord is changing the terms of my tenancy and it's resulting in me having to pay more money.
So we
I hope
also
that.
received a set of questions around rent rollbacks, and for these, the questions were very specific to people's specific scenarios, and it really kind of the amount of rent that can be rolled back really depends on when tenancy started. So I'm actually going to skip these questions and really refer people to submit their questions to the housing counselors to get more individualized counseling. So, apologies for not being able to address it in this webinar, but if you had a question around rent rollbacks and how it applies to your situation, please email a housing counselor. Again, that email is rentalhousing@cityofpasadena.net.
And Agnes, as people email in, can you please provide them what pieces of information would be great for them to send that first time around so that they don't get any lag time in the exchange?
Yeah, thanks so much, Allison. Please provide your tenancy start date and the address where you live. We really need that information to understand kind of how Measure H and how Measure H and the exemptions apply to your specific tenancy. So again, if you are emailing a housing counselor, please provide when your tenancy started and the address where you live.
Agnes? Sorry. I'm looking at them. There's a few that I can answer really quickly, unless you might have answered them.
Go for
Were
it.
you, okay, you were. One is from, well, they're anonymous. Can I stop a landlord inspection if I am a contractor so that I can do my own inspection? If the landlord has a legal right to get into your unit, the answer is no. So the thing to think about is, what's the purpose of the inspection? So one thing we commonly see in this landlord-tenant universe is the landlord thinking that I have the right to inspect your unit every year, just to make sure everything is okay, whatever okay means. That is not a right granted to the landlord under California Code, Civil Code 1954. It might be reasonable. If you're the tenant, you might agree and might not have a problem with it. But the law does not say that the landlord can just come in once a year to do some routine inspection. So this question is a little bit of a wrinkle. It depends on what the inspection is for. The fact that you're a contractor will not give you some unilateral right to stop a landlord from inspecting your unit for a legal reason. The next one generally asks, is subletting legal anywhere in California? The answer is yes. The rent control ordinance in Pasadena has some language about subletting. You can look at it there. It's very, it's sort of complicated. We really can't go into it that much. But yes, in general, subletting is legal. It depends on the rental agreement. If your landlord wanted to, they could have a lease provision that says no subletting. That is allowed. One thing to realize is, generally speaking, if your lease is silent on the issue of subletting, there's no mention about it, then there's going to be generally a presumption that you are allowed to do it, that it is allowed. So that's just something to be aware of. The only other question I can answer quickly is someone wanted to know for the owner move-in tenant protections that they wrote 5 years of tenancy and 60 years or older. The answer is yes. The starting point is you have to have lived in your unit for 5 years in order to possibly be eligible based on the criteria we mentioned before: age, disability, illness, minor child in the household. Okay, there was just 3 right there that I thought I could deal with quickly.
Awesome. I was going to ask you those. And kind of Allison put the email in the chat. The correct email is rentalboard@cityofpasadena.net. So my apologies. It's rentalboard@cityofpasadena.net, not rental housing. Thank you for correcting me, Allison. Matthew, we had one more question around single family homes. It says, are non-owner single family homes exempt from rent control? Not sure. I know that there's a lot of caveats around single family homes. So generally, can you just speak to how single family homes operate under this charter amendment and rent control?
So if you are a tenant, there's a tenant workshop in a single family home, whether or not you are covered by the rent control ordinance, the first thing to think about is, when was it rented? When did you move in? If you're a long-term tenant and you've been there before, as of January 1st, 1996, almost 30 years, and there are some of these in some rent control jurisdictions, then you have full protection under the rent control ordinance, even though it's a single family home. If your tenancy started anytime after January 1st, 1996, you have eviction protections, but you don't have the rent control protections. So the way that works in the real world is because you don't have the rent control protections, if your landlord is thinking about trying to dispossess you of your unit, there's a good chance they're going to do what? They can't evict you, but they can raise your rent because you're not covered by the rent control provisions of the rent control ordinance. So we see that a lot, and that's probably the reason why we have that 5% rule in this ordinance that says if you get a rent increase greater than 5% plus the AGA and move out because you can't pay it, you might be entitled to relocation assistance. There's always ways to possibly challenge a massive rent increase under Costa-Hawkins, because that's where this comes from. But those, again, are going to be case specific. So for instance, if your rent is $3,000 and you're in a single family home and it's not fully protected because you've only been there for 5 years, and your landlord gives you a rent increase to $10,000. Well, on the face of it, that rent increase appears to be legal under Costa-Hawkins. If you think about it, from a tenant perspective, this landlord tripled my rent plus some to $10,000. Can he really get $10,000 on the open market? The answer might be no. Again, it's all case by case. If you think that answer is no, or if you think that rent increase is somehow given to you in bad faith, not rooted in reality, or done maybe as a way to retaliate against you, to get you out, you definitely should consult an attorney to explore that.
Thank you for that. And we had one question in Spanish about when and what percent can a landlord increase rent next year? And just correct me if I'm wrong, Matthew, but I believe that to be 2.75%, which is the AGA.
That's correct.
Okay. Trying to see if there are any other questions that didn't get to. There was one question about, I know that we have 2 more minutes left and I'm trying to cram in as many questions as possible. There was one question about whether if a lease does not allow a dog, but the dog is registered as an emotional support animal, of what are generally, do you know what the protections are around emotional support animals?
Yeah, so you probably want to contact the California Department of Fair Employment and Housing. There will be local or regional offices. They can give you assistance. I've dealt with the Northern California region before. They're very good. They're very responsive. There's a good chance you'll be able to talk to a live human being about your situation and find out more legal information about the rights of tenants with support animals. I don't want to get into the difference between a service animal and an emotional support animal. That's not my field of expertise, but there are certain situations where the landlord would have to make a reasonable accommodation based on your disability to have this support animal or this service animal. That's sort of just the one-liner about it. But don't think that just because it's a dog and the lease says no dogs, that you're out of luck if you're the tenant. And especially if that dog is for something along the lines of a service animal or an emotional support animal, there is a chance, maybe a good chance, that you will be allowed to have it. But you should contact the California Department of Fair Employment and Housing. I think there's most positive, there's an office in Los Angeles.
I think Allison put a link in the chat. Right. So we are at 8 o'clock. So I'll pass it back to Allison to say our concluding remarks. And thank you again, Matthew.
You're welcome. And again, thank you everybody for attending.
Great. Thank you, Matthew. And thank you, Agnes. And thank you, residents of Pasadena, for spending some of your evening with us. We will be sending out this webinar recording as well as the slides to everyone that registered, whether or not they attended tonight. If you're a tenant and a neighbor, please share out these resources with your neighbors. Operate on the principle of each one, teach one. And also know that we have fact sheets available for tenants and landlords, such as these, at our city kiosks, libraries, and city council liaison offices, as well as City Hall. But I really just want to thank everyone for taking the time to learn about your rights and how to help us all implement this voter-approved law for the city of Pasadena. So with that, I want to thank everyone, our panelists, our presenter, our fellow tenants and board members, and I wish all of you a lovely evening. Thank you so much.
Thank you, everybody, and good evening. Take care.